Good afternoon, everyone. I'm Leslie Kendrick. I'm Dean of the Law School, and I am delighted to be here today to celebrate Professor Sai Prakash and his new book, The Presidential Pardon, the Short Clause with the Long Troubled History. I want to say several thank yous. Thanks to Micah Schwartzman and the Karsh Center for serving as the organizers and sponsors of this panel. Thanks to the many folks within the law school who've worked to make this possible: communications, law IT, building services, our events team. I see nearly all of you here on the spot today. Thank you so much for all of your work. I also want to thank our panelists, Margaret Love, Kate Stith-Cabranes, and the law school's own John Harrison for joining us today from near and far. This panel was initially scheduled to take place some time ago, and we were thwarted by one of the several snow events we had this winter. So I'm particularly grateful to you all for hanging with us during rescheduling. And finally, thanks to all of you for being here with us. I'm going to leave the longer introductions and the bulk of the words about the book to the others that you see before you hear. But I do want to say just a few things about my colleague and friend Sai and his new book. Professor Sai Prakash is the James Monroe Distinguished Professor of Law here at the Law School, as well as the Horace W. Goldsmith Research Professor of Law. He's also a senior fellow at UVA's Miller Center of Public Affairs. Professor Prakash attended Stanford University, from which he graduated Phi Beta Kappa with degrees in economics and political science. He then attended Yale Law School, where he was a senior editor with the Yale Law Journal, a finalist in the Thurman Arnold Moot Court competition, and a John M. Olin Fellow in Law, Economics, and Public Policy. Immediately after law school, Professor Prakash clerked for Judge Lawrence Silberman on the DC Circuit, and then for Justice Clarence Thomas on the US Supreme Court. After practicing as an associate attorney at Simpson Thacher, Professor Prakash entered academia. After stints at the University of Illinois, Boston University, and the University of San Diego, and a year spent in the White House Office of Management and Budget during the George W. Bush administration, we here at the law school were fortunate enough to welcome Sai and his family here to Charlottesville. In his 17 years on our faculty, Sai Prakash has made himself an indispensable member of the law school community. He's a generous colleague and mentor and an accomplished teacher, as well, of course, as being a leading voice on matters of constitutional law and the executive branch of government. He's written countless articles and book chapters, as well as 3 books. A true public intellectual, he speaks at colleges, universities, and think tanks across the country, appears on broadcast television and podcasts, writes for outlets such as the New York Times and the Wall Street Journal, and testifies to congressional committees at the invitation of both Democratic and Republican leaders. He's been a visiting professor at Harvard, Yale, Northwestern, and the University of Chicago, as well as a fellow at Princeton's James Madison Program and Stanford's Hoover Institute. In all he does, whether in the classroom or out of it, Sai Prakash brings to bear his enormous intellect, his generosity of spirit, and his remarkable abilities as a teacher. I'm thrilled for our particular occasion today, which is to celebrate this book, The Presidential Pardon, the Short Clause with a Long Troubled History. As you'll hear more, the book explores how the Constitution's brief pardon clause has grown from a mechanism of mercy that was used with solemnity and circumspection to a blunt and potent political instrument. Professor Prakash charts the evolution of the growing politicization of the pardon power as presidents wield the pardon pen for political and personal reasons with increasing frequency. The book provides readers with a history of the pardon power, how it's used today, and what we can do to solve problems and how it's deployed. Sai, I'm delighted to celebrate your latest book, your role within our law school community, and your place in the national landscape of legal scholarship. Without further ado, I'll turn it over to our moderator, Micah Schwartzman.
On behalf of the Karsh Center for Law and Democracy, which is sponsoring this event, I want to welcome all of you, especially Sai's family. His wife Rashmi and Gori are here to recognize the publication of his book, The Presidential Pardon, the Short Clause with a Long Troubled History, which was published earlier this year by Harvard University Press. The book is being praised as the best book ever written on the pardon power, and we've drawn together a distinguished panel to discuss it. I just want to briefly introduce our panelists, and then I'm going to turn things over to Cy to get us started. Next to Cy is Professor Kate Stith. She's the Lafayette S. Foster Professor of Law at Yale Law School. Prior to joining the faculty at Yale, Professor Stith was an assistant U.S. attorney for the Southern District of New York, where she prosecuted white-collar and organized crime cases. Professor Stith has served as an advisor for the American Law Institute Project Model Penal Code sentencing and on the Committee on Law and Justice of the National Research Council, and by appointment of the Chief Justice of the United States on the Advisory Committee for the Federal Rules of Criminal Procedure. She's the author of Fear of Judging, which was published by the University of Chicago Press, and Defining Federal Crimes, published by Aspen. Next to Professor Stith is Margaret Love, who practices law in Washington, D.C., specializing in federal executive clemency and restoration of rights. She's the founding director of the Collateral Consequences Resource Center and maintains the Restoration of Rights Project, a state-by-state survey of restoration of rights mechanisms that's available on the website of the CCRC. She's the author of Collateral Consequences of Criminal Conviction. Before establishing her private practice in 1998, Ms. Love served in the U.S. Department of Justice for 20 years, including as U.S. pardon attorney from 1990 to 1997. We also have with us John Harrison, who is the James Madison Distinguished Professor of Law in the class of 1941, Research Professor of Law. Prior to joining our faculty in 1993, he had a distinguished career with the U.S. Department of Justice, serving in numerous capacities, including as Deputy Assistant Attorney General in the Office of Legal Counsel. In 2008, he served as Counselor on International Law in the Office of the Legal Advisor at the United States Department of State. Professor Harrison teaches constitutional history of federal courts, remedies, corporations, civil procedure, property, and everything else. I'm going to turn things over now to Cy to give us a sense of his book, and then I'm going to ask each of our panelists to talk for about 15 to 20 minutes, followed by some time for Q&A, which I will moderate. Professor Prakash.
Thanks to the Karsh Center and Micah for organizing this wonderful event. I know that a ton of work goes into events like this, especially when you have to organize them twice, as people had to do. So thank you so much for all the work that went behind the scenes. I did nothing. I just kind of showed up, so I really appreciate it. Thanks to the Dean for all her support over these many years and her friendship as well. Thanks to my wife and children, Rashmi, Gayatri, Gauri, and Aditi Lakshmi. Only one kid came. You're obviously the best one. Please pardon me for all that I've put you through all these years and what I'll do to you in the years to come. Thanks to my merry band of research assistants, some of whom are here. I'm very grateful for all the work that you did to all the work that you did to finish this book. The book would still be in some draft form had it not been for your prodigious efforts. Finally, Larry Rambo's outside selling copies of the book, and I think it'd be a shame if he had to take them all the way back to the bookstore. So please do get a copy. Let me turn to the panelists. It's been great to get to know Margaret Love. I just met her today, and I have to say that I wish I had known her before today, because I would have given her a draft of the book and she would have helped me correct all the errors. So for the second pardon book, it will be the second greatest book on the pardon. Margaret Love will help me out. John, what can I say about John? John, I've enjoyed our conversations these many years. And John has forgotten more law than I'll ever know. And so thank you, John, for doing this today. And then last but not least, let me turn to Professor Stith. She was my constitutional law professor at Yale, my first year, my first semester. She taught me everything I know about constitutional law, and I mean everything. It was such a formative class, and her lectures and the discussions were incredible and wonderful. I liked her class so much that I took criminal law from her and I wrote a paper under her supervision. She was and has been a wonderful mentor. For instance, she was brutally honest about a draft I wrote for her. She told me, quote, "This reads like it was written by someone who wrote for Congressional Quarterly," unquote. And that was not a compliment, and so I had to spend a lot of time fixing that. But it takes honesty. People need honest feedback to get better, and she supplied it in spades. So she's always been there for me, and I'm glad she's here for me again. She's come all the way down from New Haven, and she told me, I think she took an early morning flight, and she doesn't like to get up in the morning, and so that's a special burden that she bore to come down here. So look, I'm going to briefly talk about the book. I'm not going to go on too long. The book, I could say was inspired by the events of January 19th and 20th, but I don't think that's the right word. They weren't very inspirational. As you know, President Biden issued several pardons on the 19th, and Donald Trump was sworn into office on the 20th of last year, and he issued more. There are several chapters on the book on those pardons and what they mean for the future of the pardon clause. But I thought I'd just give you a thumbnail sketch of the rest of the book. The book talks about the origins of the pardons clause and how pardon authority has existed across civilizations, but how most of our conceptions of the pardon power come from Great Britain. The states had pardon authorities. The Continental Congress had pardon authority. George Washington exercised pardon authority by virtue of a delegation from the Continental Congress, and he did so in all kinds of interesting ways, including blanket amnesties for soldiers and sailors who committed various crimes. Then it talks about the creation of the pardon power in the Constitutional Convention and the controversy within the convention, but also how it was received in the states. And it turns out no one really thought the pardon clause was perfect. Everybody understood that there were trade-offs to be made, and they decided to keep it as it was. They did not amend the pardon clause in the first Congress, and it's never been amended since. But there were controversies almost from the get-go. I have a chapter on George Washington, and he's kind of the ideal pardoner-in-chief in the book because he's very circumspect and very careful. He asks for the opinion of the attorney prosecuting. He asks for the opinion of the judge. He asked the opinion of other people. Like once he asked John Jay, the Chief Justice, what he thought about an application. And then he made a very deliberate and careful decision about whether to grant clemency or not. And in the pardon itself, and pardons are public documents, they're not really addressed to the recipient, he would describe all the reasons he had for giving the pardon, because he understood that there had to be justifications for the exercise of this awesome power. And so he's kind of the ideal president. From there, there have been a series of controversies about the politicization of the pardon power. This book is really about the politicization of the pardon power. It's not about mercy generally. And it starts off with John Adams, right? John Adams and Thomas Jefferson are both accused of using the pardon power for political purposes. So is Andrew Johnson. I won't spoil the story. You should, you have to pick up the book and take a look at that. But it's very interesting, eye-opening to me. I did not know that they were accused of this, accused of politicization of the pardon power by very prominent people. In the case of Johnson, it's clear, right? He issues a pardon on the first day of the Democratic National Convention after being told that if he issues an amnesty, it will help him get the nomination. And then he's told it's well received. So he's clearly thinking about how using the clemency power could possibly help him stay in office. He doesn't get the Democratic nomination. Of course, we all know about Nixon and Ford and the allegation of a corrupt bargain. Maybe you remember Iran-Contra and how George W. Bush issued some pardons that were controversial. The independent counsel said the cover-up is complete with the issuance of these pardons, maybe fulfilling a prediction that was made at the founding about the improper use of the pardon power, where the president himself might be involved in some shenanigans or even crimes and then would use the pardon power to cover it up. That's certainly what the independent counsel thought. It discusses the Bill Clinton pardons at the end of his term that were possibly designed to reward a campaign contributor, but also designed to support Hillary Clinton's efforts to secure a Senate seat. And then it ends, a good part of the book is on the Biden pardons on the 19th of January and the Trump pardons on the 20th, but also other Biden and Trump pardons. And I have a chapter called Our Pardon Dystopia, and I think there are 4 elements worth highlighting, and I'll highlight them for you now really quickly. One is clemency for cash, right? If you contribute to me, if you do business with me, I think you will increase your chances of getting a pardon from me, right? Assuming for a moment that I'm the president, right? I think there was a taboo about this that lasted a long time after some of the Clinton pardons, but I think it's been broken by President Trump. Clemency for votes, both Joe Biden and Donald Trump run on campaign promises to pardon people, to issue clemencies. And I think they're designed in part to secure votes. And unlike most promises presidents can make, this is a promise they can keep. And so it's you could see why it's a very potent tool at their disposal. And it has consequences for what they're going to, what campaign promises they're going to make and keep, because you might very well think that that would be something they would do quite often. Clemency for henchlings, right? Presidents might tell their henchlings within the administration, do what I tell you to do, and I will pardon you at the end of the administration. You don't have to worry about being prosecuted, right? Because I've got your back. So, follow my orders. And then finally, something I call policy pardons. The president doesn't like the environmental fines that we have for environmental dumping. The president doesn't like statutes that criminalize the use of marijuana. The president doesn't like the death penalty. The president can do away with all those offenses, right, retroactively, right? Anyone who's convicted of those offenses could get clemency, and then anyone who committed the offense while they're in office would be pardoned at the end of their term. And of course, if you don't like these statutes, this sounds like a great idea, but of course, the president won't only grant clemency with respect to statutes that you think are problematic. And more generally, the president has a duty to take care that the laws are faithfully executed. And this use of the pardon power by Joe Biden in particular, I think is problematic. So there is more in the book, but I don't want to ruin it for you, so thank you.
Along with the rest of you, I thank Cy for his important and invaluable book. About the pardon power, a power that the Supreme Court has in dicta, as far as I can tell, construed to be so broad and unbridled that it seems incongruous with the rest of the Constitution. At the end of my remarks, I may have time to suggest a political solution to this, but I know Margie's going to suggest some important institutional reforms that can be made. Now, for most of our history, it didn't matter that the president's remarkably expansive pardon power was what it is, because most presidents didn't abuse it. I'm not sure I agree all the uses Cy mentioned were abuses, but certainly some were, and in recent years it's gotten worse. That's why Cy had to write this book, to see if there's any way of putting the genie out of the bottle and to show us the absurd results when the genie has jumped out of the bottle. But let me start at the beginning. I think the framers had a good reason to put both prosecution and pardon as core executive powers. Criminal prosecution begins the case, and pardon can be its end. Now, in a system of warring factions, the pardon power can serve as a check and balance over time. The next president can undo the consequences of political or otherwise ill-conceived prosecutions of the previous president or previous administrations more generally. But the framers did not anticipate that the pardon power would mostly be used to undo the effects of political and bad prosecutions. They thought it would be used for more prosaic reasons like mercy and justice. A political pardon to remove the consequences of a political prosecution would be the exception, not the rule, even though I do think it has this check and balance effect. Alas, over recent decades, political prosecutions have been countered with political pardons, including preemptive pardons, and become regrettably commonplace. When did things really begin going south with the pardon power? Now, Cy, as he mentioned, recounts venal aspects of the pardon process with Presidents Adams, Jefferson, Andrew Johnson, Lincoln, for that matter, and his specific complaints are that they took politics into account, that these presidents were at least aware and may have been moved by the electoral advantage in granting certain clemencies. Cy's book understandably focuses on the greater abuses under Biden and Trump. But I think the pardon power really began to spin out of control earlier than Biden and Trump. I'm going to read you a passage and ask you when you think it was written. Quote, "What makes the situation intolerable is that as the official route to clemency has all but closed, the backdoor road has opened wide. In the past 2 administrations, petitioners with personal or political connections in the White House bypassed the pardon attorney in the Department of Justice, disregarded its regulations, and obtained clemency by means and sometimes on grounds not available to the less privileged. That was written in 2010 by my fellow panelist and longtime co-conspirator, Margaret Love. And Margie had issued a similar indictment 10 years earlier when she left the office of the pardon attorney. Now, I don't know if Margie would agree with my next point. I think the real rot began in President Clinton's second term. As Cy recounts, Clinton allegedly pardoned certified terrorists who killed people who were serving 30 and 40 and 50-year sentences for the vain hope, and I would say offensive hope, that somehow Puerto Ricans in New York would care about pardoning these Puerto Rican terrorists from 30 years previous, and they would vote for her. She finally had to back off on that. But it smelled terrible. And also under Clinton, we had a pardon for cash in the case of Mark Rich. I was in the U.S. Attorney's Office when Mark Rich was indicted, and I followed it very carefully. He was a fugitive. Now, we would be shocked if there were strong circumstantial evidence that prosecutors, judges, or parole officials had traded leniency for cash. Shouldn't we also be shocked at the idea of a president doing the same thing? To be sure, presidents have to run for re-election, and they must build their libraries. That's neither excuse nor justification, and we need to immediately restore the norm of open and that has been violated open and notoriously, the norm of no clemency for cash. And now, at one point, Cy surfaces the idea that maybe pardons are just like ambassadorships or appointments to a federal board. We know that presidents do bestow these goodies on their donors and friends. Why not bestow pardons? Cy doesn't adopt this idea, but he seems to think it's plausible. I disagree. I think pardons are very different from, say, ambassadorial appointments, because presidential pardon is the end stage of our federal criminal justice system. We all agree that prosecutors, judges, and parole officials may never consider personal favor or financial reward in exercising their discretion. Likewise, I urge, donations and special considerations for family and friends should play no role in presidential clemency. But what about consideration of politics? Cy is also critical of presidents considering a political advantage in bestowing clemencies. But in this respect, I think pardoning presidents are different from prosecutors and judges. The latter officers must forswear politics in their official actions. Indeed, in their official capacities, they should have no politics at all. We simply can't say that about presidents. Presidents are politicians, and successful ones at that. It's unrealistic and therefore a waste of breath to expect a president not to see political valence in his official acts, whether the act be a State of the Union address, a legislative proposal, or a pardon. So I'm going to approach this, the politics part, not from the pardon side, but from the beginning of the case, the prosecutor. If we are to stop the spiral of political prosecutions followed by political pardons, we must reestablish Attorney General Edward Levy's post-Watergate norm that presidents may not intrude on the Justice Department's decisions to investigate or prosecute. Cy may be shaking his head at this. He has referred to the president as prosecutor-in-chief. Now, Cy, I don't deny that the president has constitutional authority to order or overrule officials at DOJ. And we have seen instances, though mostly isolated, of presidents doing so over time. But from the Nixon administration through the Biden and Trump II administrations, we have also seen the dire consequences of politically driven investigations and prosecutions. So I say, the names of the president's allies and enemies should not be posted anywhere near the Department of Justice. Okay, what's the proximate cause of our current political scourge of political reprisal? prosecutions and pardons, both political. Let me propose that the problem began with the Ethics in Government Act of 1978, which included the Independent Counsel Law. Even though that law lapsed in 1999, it's never really gone away because attorneys general feel politically compelled to appoint so-called special counsel under DOJ regulations that replicate the most problematic aspects of the Independent Counsel Law. 10 years after that law was enacted in 1988, 7 members of the Supreme Court upheld its constitutionality in Morrison versus Olson. Justice Kennedy, new to the court, recused. Only Justice Scalia dissented. Scalia was right. I do not share his full embrace of the unitary executive, but Scalia was right that the office of independent counsel had done real harm to our nation. While Scalia would agree in principle with Tsai's characterization of the president as prosecutor-in-chief, and maybe I should say Tsai would agree with Scalia, looking at the timeline, but I like, we're here to celebrate Tsai, so Scalia would agree with Tsai. But Scalia didn't actually imagine the president would spend his time directing who should not be prosecuted. Rather, Scalia's insight was that the president must be ultimately accountable as a buck stops here backstop, because his very power to step in and fire the prosecutor, if necessary, has the interorum effect of thwarting ill-willed and other misguided prosecutions. Scalia understood that as long as the president has the power to remove, he will seldom have to do so. The Independent Counsel Law removed this looming presidential and democratic check on prosecution. Indeed, the Independent Counsel Law effected a massive relocation of investigatory control to a private individual subject neither to presidential control or Senate confirmation, nor realistically to the norms of Maine justice. He's untethered. Moreover, this massive reallocation was done only, and continues to be done, only in cases of high executive officials, cases that would almost inevitably be deeply political, with high partisan valence to opponents of the incumbent president. With a few notable and admirable exceptions, and here I include Robert Mueller, the independent counsels and special counsels for nearly 50 years have been accurately seen in the eyes of their targets as political agents. The targets thought that the appointed prosecutors could expand their investigations easily, and given the breadth of federal criminal law, they would be able, in the words of Justice Jackson, to find an offense to pin on their preordained target. Since 1978, we have seen plausibly characterized as partisan prosecutions by independent counsel responded to by the next president with arguably partisan pardons. Let's look at the record. First, just as the Ethics in Government Act was taking effect, the Carter administration appointed private citizen John Niels as a DOJ special counsel to prosecute Mark Felt and Edward Miller, high officials at the FBI, for alleged black bag illegal searches they had undertaken way back during the Nixon administration. A D.C. jury duly convicted Felt and Miller in 1980. When Ronald Reagan took office a few months later, one of his first official acts was to pardon Felt and Miller. Then, during the Reagan administration, private attorney, mentioned by Tsai, private attorney and former Judge Lawrence Walsh was appointed under the Ethics in Government Act to investigate the Iran-Contra affair. Walsh didn't stop when his convictions of John Poindexter and Casper and Oliver North were reversed on appeal. No, he went on. Throughout the Reagan administration and all the way through the Bush I administration, he even brought an explosive superseding indictment against Caspar Weinberger and publicly named President Bush as a target just days before the 1992 presidential election. The first President Bush lost that bid for re-election, and 6 weeks later, on Christmas Eve, pardoned Weinberger and the others. This was tit for tat, and Walsh was a tit Okay. Next comes President Clinton. I've already criticized his second-term pardons. But remember, Clinton had been the target of Ken Starr's sprawling investigation under the Ethics in Government Act. With the Republican House releasing Starr's 450-page report, it had printed up copies ready to go, alleging 11 grounds for impeachment. Now, Clinton beat conviction after impeachment, but given his targeting by prosecutor Starr, it may not be surprising that he decided to throw out adjacent norms governing pardons. Like Cy, I will mostly skip over Bush II and the Obama administrations, though the problem of political prosecutions followed by political clemency didn't entirely go away in these years. Now, on to the Trump II clemencies and the Trump II, well, I guess I missed something, prosecutions. Cy thoughtfully assesses Trump and Biden's clemencies. Since publication of his book, there has been even more evidence of the friends and family type pardons and maybe open clemency for cash. But to return to my theme, that political pardons are often the consequence of political prosecution, consider the January 20th pardons of the J6 rioters. Now, whether or not you think that Hurricane Crossfire and other investigations of Trump were partisan efforts, and whether or not you think DOJ's early decision in the Biden administration to track down and prosecute every darn J6 trespasser, whether you think those were intended to condemn Trump as well, Trump was not being paranoid as seeing them that way, seeing them politically motivated. I say this not to excuse what I consider the most outrageous misuse of the pardon power in our history, the mass clemency for every J6 arrestee, including pardons for many who engaged in insurrectionist violence. I am saying that it's no surprise that the criminal justice system is now beset with political reprisal in the form of counter-prosecutions and counter-pardons. Worse, the gotcha game has infected regular prosecutions in both state and federal court. During the Biden administration, witnessed the Manhattan DA's Bragg's prosecution of Trump. And in Trump II's DOJ, partisan prosecutorial payback is being taken to absurd levels. What can we do to stop this downward spiral? Let me hold off on my political proposal, my time is up, so you can hear Margaret Love's marvelous ideas for institutional reform.
Let me start out by saying three things that I am going to talk about, 3 points that I want to make. First, having lived with this pardon power for about 35 years now as my main professional obsession, obligation, responsibility, what have you, I think that the pardon power is no longer fit for purpose, and we should ditch it. I think Kate is largely right in what went wrong, but there are other things that have gone wrong. And perhaps this was always an accident waiting to happen, as many of the framers thought. So that's my first point. Real reform to put in place some of the systems that some states have, which seem to work pretty well, I think is not a likely feasible project from a political point of view. And I think at this point in our history, for reasons that I'll explain, I think it would probably do more harm than good. That's my second point. Third point, however, is somewhat more optimistic, I think, that we don't really need a pardon power at this point. We don't need one for the reasons that the framers thought we did. For the words of Hamilton in the Federalist 74 that have always been sort of my watchword in why we need a pardon power, which is that any nation's criminal code, and I'm quoting here, partakes so much of necessary severity that without an easy access to exceptions in favor of unfortunate guilt, justice would wear a countenance too sanguinary and cruel. So there was another reason, which has to do with a more political use of the power, where he talked about seasons of insurrection, when a well-timed offer of amnesty to the rebels will quickly put the rebellion down. But that first reason about the severity of the criminal justice system and the need for exceptions has always been one that really struck me as tremendously important. And it also struck me as I managed the pardon advisory system in the Justice Department for almost a decade and have practiced it ever since, that it just isn't the right mechanism. It doesn't work. It's not fair. Theoretically, it's not democratic and it's not fair. And theoretically, pardon is really not supposed to be fair. Justice is supposed to be fair, not pardon. And so when I think about what to do now, I think about how to incorporate what clemency does into our legal system. So let me go back to these first points again and be a little clearer on what I mean. My abolitionist view, Cy, is not based on what sort of basic objections to the absolute regal nature of the pardon power. And I want to say that for a lot of our history, the pardon power worked really well and in a pretty non-kingly fashion. To be sure, there were a lot of controversial pardons, some that people vehemently disagreed with, but for the most part, the pardon system worked in a way that Hamilton envisioned, quietly and efficiently. Abuse was largely avoided by pardons' very close ties to the legal system and responsible executive practice, to be sure. For more than a century after the Justice Department was established in 1870, the Attorney General's management of the pardon power produced no scandals, few controversies, and hundreds of grants every year to ordinary Americans. This is something that is not known as well as the controversial grants, that there was in the Justice Department a thing called the Office of the Pardon Attorney. And that was the office that I had the privilege to run for a decade. It made recommendations first to the Attorney General, and then the Attorney General made them to the President. It was a short little chain of advice there. And it worked really well, and it worked pretty well up until about 1980, which is where Kate begins the disintegration of that link to the legal system that really kept the president out of trouble and gave relief to ordinary Americans. And believe me, there were a lot of them. There were hundreds every year. And if you go to the website of the pardon attorney, you can see the hundreds of grants. They have statistics all the way back to McKinley. And you can see there were hundreds and hundreds of grants every single year. And these were ordinary people who got too long a prison sentence. Mostly, those were in the early years. And then later, suffering from the adverse, sometimes permanent effects of having a criminal record. So it worked pretty well for a long, long time. This was the Justice Department doing its work. This was the executive branch. In most cases, the president signed off on what the Attorney General recommended with the equivalent of an auto pen, if you will. The staffing was done in the Justice Department. And as I said, it worked pretty darn well. Those institutional checks on the pardon power have eroded, and I think fatally so. Beginning in the Clinton administration, although there were signs before that time, the kind of reckless and self-serving pardons that we've seen in the last 18 months are a kind of a testament to the corruption, I think, really of the pardon process and of the pardon power. I'm an optimist, I suppose, by nature, and I see it kind of as a gift. It's a blessing in disguise, I think, because all of a sudden now we have to look at this power and we have to decide, is this something that we want to live with, or is there an alternative? Now, let me first say that I think the ideas for reform that have been rolling around, some of them are pretty good. I think most of them are pretty unrealistic. Some states, I would say, have darn good systems. Virginia has a not bad system, but the ones that are really good, most of the constitutions not only give the governor the power to pardon, but they also say that the pardon power will be exercised in accordance with law, in accordance with rules that the legislature imposes. So things work in a pretty regular way and in a pretty responsible way. Now, if that were possible to make those kinds of reforms, it would really cause an entire upheaval of the Constitution. I think there'd be a lot of pretty bad ideas thrown out there, and we'd be in a huge debate for a long time. So my preference, really, is not that we throw the baby out with bathwater, as Sy says in the book that he regards the abolitionist viewpoint, but that we tell the baby it's kind of like time to stand up and get out of the bath and grow up. Grow up. I mean, we don't need a pardon power anymore. And in a lot of ways, just having a pardon power distracts us from making the kinds of changes in the law that we need to make in order to make our system fairer. And I'll give you two examples of that. One is an authority that actually President Trump signed into law in his first term, which is the authority for federal courts to reduce prison sentences if they believe that there are extraordinary and compelling reasons to do so. Now, this is an authority that's been around in the law for 40 years, back in the old law time when you just had to advance parole eligibility. It didn't work because the Justice Department, which was by then, this is another element, had gotten very tough and had bought into the agenda of the war on crime and didn't want anybody to get out of prison early. So it didn't work until the Justice Department, in the form of the prison authorities, were taken out of the gatekeeper role so that people could go directly back to court to see if they could make the case that the sentence that had been imposed was either too harsh in the first place or circumstances had intervened that made it now too harsh to serve out the rest of their term. This law is a good law. It could be a better law. The Sentencing Commission, the U.S. Sentencing Commission, is supposed to develop policy to implement this law. It's been pretty timid in that regard. There are actually 2 cases in the Supreme Court right now, in fact, they might be decided tomorrow, that involve this authority. So keep your eye out. One is called Fernandez, and the other one is called Carter. But anyway, that's something I'm keeping an eye on. This is a law that could work. This could take the place of a pardon power. Another law is the law that I get in trouble because I live in the District of Columbia, so my friends don't understand why I am advocating for restoration of firearm rights to people, but lots of my clients think this is important. In the federal system, if you have a federal felony conviction, you cannot have a gun. End of story, full stop, forever, unless you get a presidential pardon. So there is a law that allows the Attorney General to restore gun rights. It has not been operational for 30 years. Congress pulled funding, after the agency, ATF, that was supposed to be implementing this law, gave gun rights back to too many people that abused the privilege. This is a right that people have, they have a right, there's a constitutional right to bear arms, as we know. So now finally, the Justice Department has decided it's going to revive this authority to restore firearms rights administratively. I've been told, and I think this is borne out in my own practice, that as much as a third of the very large case backlog that is in the pardon process is from people seeking their gun rights back. Now that's kind of stupid, to have the President of the United States responsible for being a kind of one-man gun licensing bureau. I mean, seriously, that's what that is. So that's another law that could be greatly improved and could take the place of pardon. It does take the place of pardon. So my own feeling about things is that we would be much better off if we simply took pardon off our plate as something that distracts us, worries us, angers us, gives us false hope, and concentrate on the harder, perhaps tougher, business of democratic law reform. So that's my feeling about what we should do with pardon. And I would be very delighted if we have time, if we could have some questions challenging me.
Thank you. I have two observations and a question, all designed to reach out to other parts of the structural Constitution. In addition to the pardon power, I have a lead-in anecdote for the first observation. The lead-in anecdote is that last summer, the Senate Judiciary Committee was conducting a hearing on the previous administration's use of the auto pen for pardons and for other purposes. Appropriately, they wanted to get Sai Prakash to testify. Sai was unavailable, so they were forced to get somebody else. And I will now demonstrate how I wasted my youth by saying this made me think, if the Avengers can't make it, get the X-Men. That is a lead-in to saying something that connects to the auto pen and pardons, other uses of the auto pen. The possibility I want to suggest is that Congress by statute provide that pardons to be effective either must be in writing or must be reduced to writing within some reasonable time, make it 48 hours, 72 hours, something like that. That proposal is similar to what I told the Judiciary Committee last summer, which is that I think that Congress should adopt legislation providing that whenever the president uses the auto pen for a document that's going to have legal effect, somebody in the White House should have the obligation to produce a document saying that the president instructed me to put the president's signature on something by auto pen, so that there will be a record showing that, yes, the president for some reason decided not to sign this manually, but the president made the requisite choice to do something that's done by signing a document. What brings the two proposals together, the proposal about pardons and the proposal about the auto pen, is they would both be exercises of a power that's very important but does not receive all the attention it should. It's the so-called horizontal necessary and proper power. At the end of Article 1, Section 8, the Constitution authorizes Congress to carry into execution the foregoing powers. Those are the other powers granted to Congress on the list in Article 1, Section 8, and all other powers vested by this Constitution in the government of the United States or any officer or department thereof. The last two parts, other officers or departments of the government of the United States, generate what's called the horizontal necessary and proper power. Horizontal because we think of the three branches as being along a line, not one of them as being supreme, but it's nevertheless true that only Congress has the legislative power. Therefore, only Congress can take steps that require something that is legally enforceable, like a statute. There are lots of situations in which the horizontal necessary and proper power is necessary, as it were, and very important. For instance, courts can't make it a crime to falsify a judicial record. Congress can and has done so from the beginning of the country because there are some kinds of supports that the other powers can use that can be produced only by legislation. The tricky questions that arise under the horizontal power are generally those that come up when there's a question, is Congress trying to take control of the other power by ostensibly legislating in order to carry it out? That's a real problem. There are people who take a substantially more narrow view of the horizontal power than I do because they're very worried about that. I think the question that divide the line between permissible and impermissible exercises of the horizontal power is drawn by asking, does this make the power more effective? And if it imposes any burdens, does it impose only minimal burdens on the power? For the use of the auto pen and for pardons in reduced to writing, it's really useful to have authoritative records. It's very bad, and it's bad for the president and the pardon power for people to have to wonder whether he really granted that pardon when somebody called him up in the middle of the night or he decided to tweet one out at 3 a.m. Better to have reliable documentation that will make the power more effective, and it is possible to design something like that in a way that will have only minimal intrusion on what's really constitutionally important, which is the president's ability to exercise discretion. So that's my observation. That's observation number one. As I say, I think it reaches out to other parts of the constitutional system. If Cy has any thoughts on this, I think I've already told him this. I'd be interested in hearing them. Observation number two has to do with the possibility, Cy talks about this in the book, and it's a real problem, the possibility of what's called self-pardoning. That is, can the president pardon the president? There's a natural tendency to think, well, that would be very bad. And so the Constitution must implicitly forbid it. I don't think that's right. I don't think there's a categorical principle against the president pardoning the president. And again, one useful way, I think, to think about lots of legal problems, including problems involving the structural Constitution, is to go beyond the initial thoughts that might cause you to think there's a problem and try to think about other situations in which a power might be used in a way that you first thought was problematic but turns out not to be problematic. So here's the hypothetical I came up with. Suppose there's a presidential candidate who is not a career politician, but who rather is a public intellectual or thought leader or something like that, the leader of a political movement without being a professional politician, for example, Abraham Lincoln, who was best known, he had served one term in Congress a long time ago when he ran for president, but he was best known as a Republican thinker, somebody who articulated the Republican position that slavery should not expand beyond the states where it already existed, and was best known for his public lectures and debates and statements on that subject. Suppose somebody like that, who was had a political position that was also a moral position, organized some form of civil disobedience to a federal law, and that person and a lot of that person's political friends engaged in civil disobedience were arrested, prosecuted, and convicted, and managed, as the saying goes, to sear the conscience of America by what they had done, causing that person to be elected president, and the person pardoned everybody, including one of the participants who was the leader of the civil disobedience. I don't think that would be bad, and I don't think that's a far-fetched possibility. It's important to think about the sort of things that we don't immediately think about, but that can really happen. The point, I think, that reaches out to other aspects of constitutional interpretation in general and the structural Constitution is that anytime you're asked to find an implicit limit or an implicit qualification or an implicit something in anything that's conferred by a written text, like, for example, the pardon clause of the Constitution, I think you should ask, Well, if there seems to be an obvious reason why there's an implicit limit, maybe I'm missing something, maybe I'm missing another possibility. And that's a reason to think, as I suggest, about uses of a pardon of oneself that really aren't so bad. And the next point related to that is to see that the problem of self-dealing is not confined to the pardon power. All the powers that are in the president, because they are in one person, are subject to a particular form of abuse. There's no question about that. The pardon power can be abused to advance the president's personal interest. The veto can be abused to advance the president's personal interest. The president who has, not that there would ever be a president who had major holdings in various kinds of investments, but were that to happen, the president might enter into or not enter into a treaty that would have effects on the president's personal investments. That problem, presidential self-dealing, is a broader problem than the pardon and possible misuses of the pardon. Whatever are the Constitution's generic ways of dealing with that problem, and let's hope it has some, preeminently the possibility of impeachment, conviction, and removal from office, those generic means of dealing with misconduct by a president who's engaged in self-dealing are the solution, not finding implicit limitations in the other powers, be it the treaty power, the pardon power, or the veto. So again, I think that that observation specifically about the pardon power has something to say about the way the whole system works. Those are the two observations. Now the question. And this is, I'm going to show that I was never a litigator because I'm going to ask a question to which I don't know the answer. You know, the litigators have this saying, never ask a question unless you know the answer, right? Well, here I am. I'm a law professor and not a litigator, so I'm going to ask a question and I don't know the answer. But it responds to something that Cy talks about, that you've heard a little bit about before, that I think is very important, which is what Cy calls policy pardons. That is the possibility that presidents now will increasingly use the pardon as a policy tool to implement their views about what the criminal law should be, who should be punished for what, and who should not be punished for what. We've seen that in recent years. Cy raised some really important questions about it. My question, and again, this connects to larger issues having to do with the workings of the constitutional system, is suppose that became common. What would the new equilibrium look like? There are lots of moves that sort of work only if they're unexpected, kind of like inflation to increase employment or the Spanish Inquisition. They operate properly only when unexpected. But once you know about them, they become part of the system and people adjust to them. For example, if everybody knows that policy pardons are part of the system, what will people who want their policy goals to be achieved through federal criminal law do to keep the pardon power from undoing anything they have gotten by having federal criminal law take some form? Will they, in order to support a presidential candidate, will they demand that the candidate promise not to use a policy pardon on that issue? The political system makes possible all sorts of ways of dealing with that question. My point is, if policy pardons become common, that's only the first step. There will then be feedback effects. And after a while, there will be a new equilibrium where ex ante, everybody knows there might be policy pardons. And as I say, they will adjust their political behavior in light of the possibility that there will be policy pardons. As I say, I don't know what the answer to that question is. I think we may well find out. I think Cy is right that this is an important development and that it may well become part of the president's repertoire. And my point is, if it does, somebody's going to notice. The people who benefit from the criminal laws and don't like pardons are going to realize that, and one way or another are going to react. How they're going to react, I don't know, because as I say, I'm a law professor and I have the luxury of asking questions to which I don't know the answer. Thanks.
Before we do that, I want to thank all of you for a very rich conversation, and thank you to Cy for publishing this book. One last plug for the book. I think Larry Rambo is still outside with copy suit if you want to grab one on your way out. Thank you all.
Thank you,